All right, good morning. Welcome to the 294th District Court. My name is Chris Martin. I want to call this morning's criminal docket. When you hear your name, please say present or here. Courtney Atwood. Court finds that she has submitted documentation that she's at the Texas Recovery Center. The court has reset arraignment to January 21st. In each case, CR 24-196 and CR 24-197, which were set for arraignment today. Misty Backus. Corey Bird. Court finds that Mr. Bird was arrested in Gregg County and is on a U.S. Marshal detainer. We'll recall that case. Tammy Crocker. Here. Noemi Esquivel. Noemi Esquivel. Esquivel's not here. Jennifer Jacobs. Jennifer Lynn Jacobs. Dante Major. Lena Price. Jeremy Snelson. Alexis Stevens. Alexis Shea Stevens. Keith Thomas. Avery Tienda. Jesse Lowry. Shiloh Scott.
Counsel, Your Honor.
Thank you, Ms. Harrison. James Godwin. And I see Mr. Godwin on Zoom, so we'll recall that here. Hannah Hampton. Court has received some information that Ms. Hampton's could be in the hospital, so we're trying to confirm that. We'll recall that. Damon Watson. Robert Burke, motion for continuance filed by Mr. Rosenstein that was granted by the court. Pretrial was set January 21st, 25. Is Mr. Burke here? Sure. All right, Mr. Burke, if you'll check in with the pretrial release officer and sign your notice of appearance, then you do not need to stay around, okay? Just make sure you do those two things before you leave. David Combs. Drake Andrews. John Dickerson. Fernando Hernandez. Gerald Holmes. Jeremiah Holmes. Jeremiah Garin Holmes. Leola Jackson. Adriana Jacobs. Adriana Marie Jacobs. Any word on her, Mr. Schmidt?
Yes, yes.
Braxton Johnson.
I think it's
Jesus Landa. Kathy Leha. Sean Schnack. Jeffrey Walker. Gilberto Jimenez. Kit McNinch. All right, is there anyone who's present you've not heard your name called? Ms. Esquivel, I've got you now. Thank you. Mr. Davis. All right, thank you. All right, anyone else? Your name's not been called? All right, do we have anyone that's ready? Counsel? Harrison, you ready?
I can make an announcement on our pretrial. Page 3.
Shiloh Scott, CR 24-225. Ms. Scott is set for pretrial today.
Your Honor, we did file pretrial motions. We have nothing that court needs to take up today. I've spoken with Ms. Curry. We have the discovery. She and I would ask the court to reset for one more pretrial after the first of the year. our preference would be February, if that would be okay with the court. She has some things, she's not ready to move forward yet. She's got some things on her end she's discussed with me. Likewise, we're in the same situation.
State.
Your Honor, state has no objection to another pretrial setting. State would ask, however, that Ms. Scott submit to a UA today.
Any objection to Mr. Harrison's request to set it in February?
No objection, Your Honor.
All right, Mr. Harrison, do you have your calendar with you?
Yes, sir.
Have February 11th or 13th?
Judge, it looks like we're good either way.
Either one? Which one do you prefer?
Let's do the 11th.
11th? All right, court sets Ms. Scott for pretrial hearing February 11th at 9 a.m. And Ms. Scott, I need you to submit to your analysis exam before you leave today. Okay, so do that and then remain here until I release you further, okay? And then who's gonna be doing that? Gonna be doing that? You wanna add the hallway? Okay, you can either sit in the courtroom or you can sit in the hallway. Officer Mature will be with you shortly.
Thank you.
Briefly approach, Your Honor.
Yes. We have any other councils ready? Hawkins, you ready? Mr. Godwin? Good morning, Mr. Godwin. Can you see and hear me okay?
Yes, sir.
Excellent. All right, I'm going to call your cases. Do you see your attorney, Mr. Hawkins?
No, sir, I can't see him.
You may have to move left or right on your screen there, and you'll be able to see him. This is cause numbers CR 23-140, CR 23-141, State of Texas versus James Wesley Godwin. Mr. Godwin is appearing today on docket call and via Zoom with court's permission. Mr. Hawkins, any announcements?
Your Honor, if the court will recall, my client's been dealing with I guess a cancer. He's been in rehab. He's getting closer where he can actually be mobile. We're asking the court, I know it's been reset a few times because of his condition. We're asking for one more setting. We believe that'd be enough time to allow him to be mobile. And then I believe also we'll be able to move this case along as well.
How much time are you requesting, Mr. Hawkins?
This is just another month, just 30 days. And then we can, hopefully by that time, Mr. Godwin will be able to walk a little better. He's only able to walk about 30 yards without significant swelling.
Any objection?
In light of the medical situation, no, Your Honor, thank you.
All right. What about January 21st?
January 21st is good, Judge.
All right, Mr. Godwin, the court's going to order you appear in court for docket call with Mr. Hawkins on Tuesday, January 21st, okay? January 21st at 9 a.m.
Yes, sir. Thank you.
Welcome. You're free to go.
Thank you, Your Honor.
Thank you.
You're welcome.
That's all.
Yes, thank you, Mr. Hawkins.
Thank you, Judge.
Any other counsel ready?
I'm ready, Your Honor.
Good morning.
Good morning,
Your name?
Judge.
Your name?
I'm Tim Clancy here for Jesse Lowry.
Thank you, Mr. Clancy.
Your Honor, we may approach just briefly.
Yes. All right, this is cause number CR 24-171, State of Texas versus Jesse Lee Lowry. Court has recognized the Honorable Tim Clancy as counsel now for Mr. Lowry. The court finds that there's an agreement to reset docket call to give Mr. Clancy an opportunity to review discovery. Court will set Mr. Lowry for docket call hearing on January 21st at 9 a.m. And once he signs his notice of setting, he gets the yellow copy, white one stays here, and he's free to go.
Okay, thank you, Judge. I appreciate it.
Well,
We'll see you next setting.
All right, do we have any other councils ready? Mr. White? Yes. State.
Operation after Christmas.
Mr. Jimenez. This is cause numbers CR 24-210 and 211. State of Texas versus Gilberto Juarez Jimenez. We're set for pretrial. Mr. White, go ahead.
Your Honor, we're gonna need a contested date, and I believe that's gonna be March 27th.
Any objection from the state?
No objection, Your Honor.
All right, court sets Mr. Jimenez for contested evidentiary hearing March 27th at 9 a.m. You're free to go. Mr. McNinch. Cause number CR 24-217, State of Texas versus Kip Ross McNinch. All right, Mr. McNinch is set for pretrial today.
Your Honor, we don't have any contested pretrial or anything. We've, by the court standing order, asked the court to move this to docket call on March 25th.
Any objection from the state?
No objection, Your Honor.
There be no objection. Court sets Mr. McNinch for docket call hearing March 25th at 9 a.m.
Your Honor, that's all I have.
You ready?
Judge, I'm here on Miss Hampton, ready to make an announcement on her.
Court calls, cause number CR 390, state of Texas versus Marie Hampton. On motion to adjudicate, any update on the information about Miss Hampton being in the hospital?
Judge, not at this time. I spoke to her bondsman, or former bondsman, and he received the same information that I had. My understanding is that she went to the hospital at 2 o'clock this morning. I've not heard from her any information directly from her, so.
If the court does a judgment outside, you and me take that under advisement, give you some time to see if you can come up with some documentation to support it.
I would ask the judge, if you don't mind, extending that out to the end of the week, just to give me some time to follow up, coordinate with Mr. Nicholas on her situation.
Any objection, state?
No objection, Your Honor. Thank you.
All right, let's go ahead and set this for evidentiary hearing on January 23rd. And the court will take the judgment nisi alias KPS for failure to appear today under advisement. We'll take that under advisement until noon on Friday.
Thank you, Judge. I believe that's all I have this morning. May I excuse?
Yes, thank you, Mr.
Judge.
Schmidt? Yeah. Have they already signed it? David Wayne Combs. All right, this is cause number CR 24-94, State of Texas versus David Wayne Combs Jr. Mr. Combs, sir, if you'll raise your right hand, I'm going to place you on oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Thanks, sir. You can lower your hand. Your name is David Wayne Combs Jr., is that correct?
Yes, sir.
And Mr. Combs, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
Oh, sir.
In this case, you're represented by your attorney, Mr. Brian Schmidt. Are you pleased with Mr. Schmidt and the work he's done for you?
Yes, sir.
Do you have any questions about your case or anything before we proceed further?
Oh, sir.
Do you understand everything that you have read and signed today as part of your plea agreement?
Yes, sir.
Mr. Schmidt, do you believe Mr. Combs to be competent?
Yes, Your Honor.
And you've explained to him his rights as they pertain to this case?
I have, Your Honor.
And do you believe that he's entering into this plea agreement intentionally, knowingly, and voluntarily?
Yes, sir.
All right, Mr. Combs, you were originally indicted with a third-degree felony offense of deadly conduct, discharging a firearm. It appears that the plea agreement and the recommendation from the DA's office today is for you to be allowed to plead to a lesser included offense of a Class A misdemeanor deadly conduct. A Class A misdemeanor carries a range of punishment of confinement in the jail for not more than 365 days or a fine not to exceed $4,000. I see that the plea agreement in your case is upon your plea of guilty to that crime. The DA's office is recommending that the court convict you of the offense and assess your punishment at 2 days confinement in the county jail, with you receiving credit for time already served. In addition, the assessment of a $2,000 fine, a weapons forfeiture of the firearm that was seized in this matter, which appears to be a American Pride 1022 and also a Ruger. In addition, you would be obligated to pay your financial obligations today, which includes your fine, your court costs of $270, your reimbursement fees of $35. Is that your understanding of the plea agreement?
Yes, sir.
That's what you're asking the court to approve?
Yes, sir.
All right, Mr. Combs, understanding the plea agreement and the range of punishment for that Class A misdemeanor, this time, how do you plead to deadly conduct, a Class A misdemeanor?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
Oh, sir.
You're not chewing gum, are you?
Yeah.
Sure. Well, let's spit it out. Right here, just throw this Jersey. All right, the court will accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the stipulation of evidence?
No, Your Honor.
Stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, Your Honor.
Right, so I see that there's two stipulations of evidence. One that just says the allegations in the indictment are true, and then the other one. They're both entitled stipulation of evidence. One states exhibit 1 and one's not marked. Do you want me to mark one of these as states exhibit 2?
I apologize, Your Honor. The plea packet automatically printed the one that says State's Exhibit 1. The one we intended was the unmarked.
All right, I'm just gonna mark that as states exhibit 2.
Thank you.
Any objections to stipulation of evidence states exhibit 2?
No, Your Honor.
That is it. All right, the court, having reviewed the evidence, finds that there's sufficient evidence to convict the defendant of this offense. The court will follow the plea agreement today. The court convicts David Wayne Combs Jr. of the Class A misdemeanor offense of deadly conduct. The court assesses punishment at 2 days confinement in the Van Zandt County Jail. Court issues a credit to Mr. Combs for 2 days of time already served. The court orders him to pay a $2,000 fine, $270 court costs, and reimbursement fees of $35. Court orders that to be paid today. Court also orders that the weapon seized be forfeited as outlined in the judgment. All right, Mr. Combs, you hereby remain into the custody of the sheriff, so he can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with the deputy, and after that, you can step across the hall, make payments of your fine, court costs, and reimbursements.
Judge, I'll take him across the hallway.
Thank you, sir. Is
Take
that all?
care of that, and then might be excused after
Yes, sir.
that.
Is that all you have on today's docket?
Yes, sir.
Anything this afternoon?
No, sir.
Okay. Good to see you. Have a good day. Oh, no problem. Thank you. Good to see you. I asked.
And Your Honor, may I approach?
Yes, sir. All right, Ms. Price, this is a sanctions court hearing. It looks like you did your 1 day in jail. You completed that. You complied with your probation fees. You complied with your collection fees, and you worked your 15 hours community service, correct?
Yes, sir.
All right, what I want to do is I'm going to reset you for January 21st. And I want you to pay your $60 for probation, 65 to court collections, work your 15 hours community service. And then I want to amend your conditions of community supervision for a substance abuse evaluation.
Okay.
Once you sign that, then come over here and see Officer Mature, and she'll have paperwork for you. Keith Thomas. Morning, Mr. Thomas. How are you? How are you doing? Doing fine, sir. All right, this is a hearing on your sanctions court. And it looks like you paid your probation fee, you paid your clerk fee, and you worked your 25 hours community service. So that's a good job. All right, court's going to reset you for another sanctions court, January 21st. And we'll do 60 to probation like you did, 150 to court collections, 25 hours community service. It says that you're set to expire in March 7th next year. So it's coming up pretty close. It says everything's due in full by February 7th in order to expire on time. So looks like you're still pretty delinquent on your community service.
So I have 193 hours.
I mean,
193.
193. So not sure that we're going to meet that deadline, but we'll talk about it as we get closer. But I just wanted to remind you that because you're kind of falling behind, we're going to probably end up getting extended so that you can finish those things out. But anyway,
I'm gonna try to have it done by then.
okay. Well, I'm not gonna hold it against you if you don't have it all done by then. As long as you keep on doing this, and making good progress, and we're gonna be in good shape, okay?
Okay.
So I'm gonna have you come back on January 21st. Tammy Crocker. All right, Ms. Crocker, this is a sanctions court hearing. Looks like you paid your $100 to your restitution. Looks like you came up short on your probation fees. What happened?
I made that payment yesterday, sir. I've been sick and over the weekend I couldn't get the online app to work.
But you said you did get it paid in full
Yes,
yesterday.
I have a copy of the receipt on my phone if you'd like to see it.
I'm gonna take your word for it, and probation will double check. If
Yes,
that's
sir.
not true, they'll let me know.
Okay, thank you.
All right, so I'm gonna reset you then for January 21st and order the same thing, $90 to probation
Yes, sir.
fees and 100 to restitution, okay?
Yes, sir. Thank you.
You're welcome. Once you sign and get your yellow copy, you're free to go.
All right, thank you. Merry Christmas.
Merry Christmas to you. Misty Backus. All right, Misty, in sanctions court, let's see, you paid your $65 probation fee. You did your 24 hours community service, that's good. You did your monthly counseling, that's good. Let's see, I ordered you to pay $50 to Mr. Jakes towards your balance. Looks like you paid more. Looks like you paid 90, so that's good. You came up a little short on your court collections.
I have the receipt right here.
Did you end up paying the rest of it?
I paid
20?
65 and then 115 this morning.
You paid 115 this morning?
Yes, sir.
Okay. But you had already paid 20 towards that, hadn't you?
Not this month.
No, they indicated that you paid 20 towards it.
No.
You said you paid in full today?
Yes, sir.
All right, then what we'll do, Misty, is we'll come back on January 21st. And let's continue on the same pattern here. Let's do 65 for probation, 115 to your court collections, 24 hours community service. Where did you do your last 24 hours?
Mana.
10-year monthly counseling, pay $50 towards your balance owed to Mr. Jakes, minimal. It says your remaining balance is 145, just so that you know.
Okay.
In case you did, okay? And I've got a note here that says that Mr. Jakes will discharge you from counseling once the balance is paid, okay?
Yes, sir.
All right, Misty, once you sign and get this yellow copy, you're free to go.
Thank you. Merry Christmas.
Merry Christmas to you too. All right, Mr. Snelson, I think today I'm pleased enough to let you out of sanctions court. Feel like you're gonna be able to take on your conditions without me constantly asking you every month. You agree?
Yes, sir.
All right, so make sure that you stay in contact with your probation officer and do us both a favor and don't make me have to come back and babysit you on your probation, okay?
Got it.
All right, have a good day.
Thank you.
Ready to go. Mr. Tienda? All right, this is sanctions court for Avery Tienda. All right, Mr. Tienda, let's see. It looks like you didn't take your ID to jail for the first time, right? So you still owe me 2 days in jail, right? You agree? And then you learn from that lesson. And then on the second half of your time, you took your ID and you did your 3 days, right? All right, so there's 2 more days and Officer Matura, she's got an order. We went ahead and picked the days for you. It's gonna be before Christmas, okay? The only other thing I want you to do besides the 2 days that you owe me is I need 10 hours of community service and $115 towards your probation fees. We're gonna come back on January 21st, okay?
Sure.
So 10 hours community service, $115 towards your probation fees, and then do your 2 days, and we already have those days picked out for you, all right?
All right, yes.
All right, sign this and then come see Officer Mature. All right, for the record, this is cause number CR 24-201, 202, 203, 204. State of Texas versus Corey Michael Byrd. Byrd, having previously been set for arraignment, was reset for today to hire an attorney. It appears that Mr. Byrd has been arrested in Gregg County and is on a U.S. Marshal detainer. We've received information from the bondsman that Mr. Byrd has been appointed a federal defense attorney, Mr. Ken Hawk. And so I'm going to go ahead and reset Mr. Byrd. We'll reset them to February 11th. I don't know if the state wants to reach out and talk with the U.S. Attorney's Office, find out if they're moving on charges that may delay or interfere or otherwise affect our cases.
Yes, sir.
Just going to reset that for arraignment status on federal custody. Jennifer Jacobs here. Still not. Court's going to stand in recess and give Mr. Schmidt an opportunity to finish speaking with his clients. Probably going to be at least 20 minutes or so. So it's about 20 after. So you can check back in about 10:40. Okay. We're in recess. Clinton, are you and Mr. Watson ready?
We are, thank you.
Come on up, Mr. Watson. This is cause number CR 24-121, State of Texas versus Damon Scott Watson on docket call. Go ahead, Mr. Clinton.
Your Honor, we're here today and provided everything works out with Mr. Watson's drugs test today. We have a plea agreement worked out that we would take care of at the next appearance.
State.
That's correct, Your Honor. State is going to request that Mr. Watson submit to a UA today, providing the UA is clear. We have an agreement, and we have an agreed waiver of jury trial in order to effect that for an additional setting, because this one has been carried on for a few additional settings.
Okay. All right, Mr. West, would you administer a UA to Mr. Watson? You can come on back here with Mr.
That way?
Watson. Yes, and then I'll recall your case.
Yes, sir.
That's it. Hello.
Y'all have done the waiver.
Yes, sir.
Yes, he's already signed it, Your Honor, and we're ready.
You ready to display? Yes, sir. Mr. Watson, come on back up. All right, we are back on record, call number CR 24-121, State of Texas versus Damon Scott. Court finds that pretrial release officer has conducted a urinalysis test of Mr. Watson, and that Mr. Watson is negative of any controlled substances at this time. What's the next announcement?
Your Honor, there is a waiver of jury trial that also enshrines the plea agreement.
You have that, Mr. Butler?
I do, Your Honor.
Yes, sir, please.
There's also the,
There you go, I'll let you keep that one. All right, Mr. Watson, I'm going to take some testimony from you today on the issue of your waiver of jury trial. So if you'll raise your right hand. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Your Honor.
All right, you can lower your hand. All right, Mr. Watson, today you're appearing in court with your attorney, Mr. Eric Platten, correct?
Yes, yes.
And
Sure.
it appears to me that you are wanting to waive your right to a trial by jury in order to accept a plea agreement being offered by the state. Is that correct?
Yes, yes, sir.
And I want to go over some of your rights that are embodied within your right to a jury trial. And first, you need to understand that you and only you can waive your right to a trial by jury. Do you understand that? Mr. Platten can't waive it, the court can't waive it, and the state cannot waive your right. It can only waive its own right. Do you understand that?
Yes, yes, sir.
That means that I need to be assured that you are wanting to waive your right to a jury trial because that is your independent decision, and that you're making that decision free of any pressure or coercion, and that you're entering into it intentionally, knowingly, and voluntarily. Does that make sense?
Yes, yes, sir.
So has anybody threatened, forced, or pressured you to waive your right to a waiver of a jury trial?
No, sir.
And do you understand, Mr. Watson, if I approve this today, that once you accept a plea agreement, and even if you don't accept a plea agreement, the court may not establish that right for you again, meaning you may not be able to get that
Yes, sir.
back.
Yes, I understand.
Okay,
Yes,
that,
sir.
you understand that if you're on, let's say the court accepts this and you accept the plea agreement, and later at a revocation hearing, if you violate any of the terms, you can't say, Judge, I want my trial at this time. You understand that?
Yes, yes, sir.
All right, and you understand that by giving up your right to a jury trial, you're also giving up your right to subpoena witnesses and confront and cross-examine the state's witnesses and the evidence in front of a jury. You understand that?
Yes, sir.
All right, so understanding all that, Mr. Watson, today you're telling me that you are wanting to waive your right to a jury trial.
Yes, sir.
And it appears that the agreement is that Mr. Watson would be pleading guilty to the underlying offense in which the state's recommending at a later time that the court impose an 8-year sentence, but to suspend that and place Mr. Watson on community supervision for 4 years. Is that correct?
That's correct, Your Honor.
Okay. All right, Mr. Watson, the court's going to find that you have intentionally, knowingly, and voluntarily waived your right to a jury trial, that you have received the advice and assistance of your counsel, Mr. Platten. I see his signature here on this document. And the court finds that the assistant criminal district attorneys have waived their right to a trial by jury for the state's case as well. So the court approves the waiver of your jury trial. Court will set this matter for plea before the court. When do you want to do that, Mr. Platten?
what options do you have?
Do you want it? This is my last setting for this calendar year. So in January, I have 3 dates. I've got January 7th, January 9th, or January 21st. 7th, 9th, or 21st.
First may be better, if it's, sort of a morning. It would be, but me getting Smith County kind of wrapped up and coming over here like I've been doing.
All right, court sets Mr. Watson then plea before the court on Tuesday, January 21st at 9 a.m.
Thank you, Judge.
You're welcome. Once you sign and get your yellow notice, you're free to go, Mr. Watson. Thank you, Mr. White. Good to see you. All right, the name Jeremiah Garion Holmes was called. He was not present. His name has been called loudly, distinctly 3 times in the courthouse with no response. Court hereby issues a judgment nisi and alias capias. In addition, the court has called the name Jennifer Lynn Jacobs. Ms. Jacobs was not present at this time. Her name has been called loudly, distinctly in the courthouse 3 times with no response. Court hereby issues a judgment nisi and alias capias. Dr. Call first.
Ms. Brumley, Jackson.
Jackson, please come forward. Leola Autry Jackson, the state having filed a motion to dismiss the case, the court has granted that. Ms. Jackson, you're free to go.
Love to. And see you later. You're done. All right. Be happy. Yeah, and you can go home. I'll see you next.
Thank you.
Drake Andrews.
Mr. Andrews. This is cause number CR 24-89, State versus Drake, Alan Andrews for docket call. Go ahead, Mr. Schmidt.
Judge, I provided the DA's office last week with some additional evidence. I'm hoping we get to where we need to be here shortly, but we're gonna ask for another docket call.
That's correct, Your Honor. I know Mr. Schmidt's been working on sharing some evidence that he's uncovered as well. We'd ask for one more recess so that we have a chance to review that, and we'll be able to make a final announcement at the next setting.
You want January 21st? All right, court sets for final docket call, January 21st at 9 a.m. Once you sign, you're free to go.
Yes, sir. Thank you. Judge, I don't believe the state has signed anyone. All right, buddy. See you later. Merry Christmas. Meet you, man.
Who's next?
John Dickerson.
Mr. Dickerson. This is cause number CR 24-180, State versus John Franklin Dickerson for docket call.
I'm doing good.
Go ahead, Mr. Schmidt.
Judge, same kind of announcement. I've given the DA some additional information to look at. I think we're making progress. We asked for another docket call from Mr. Dickerson.
No objection, Your Honor.
All right, there being no objection, the court sets Mr. Dickerson for additional docket call, January 21st.
Reset. Go back and join. Thank you. Braxton Johnson.
Braxton Johnson. This is cause number CR 24-166, CR 24-273. Mr. Johnson set for docket call in the former and arraignment in the latter. Are you ready for arraignment on the possession of marijuana from February 23rd, 2023? It looks like same charge, same offense. There's something missing.
Yeah, I think there is something you're missing, Judge. I think there's something I'm missing as well. I can't recall if I discussed this with the DA's office last week. Mr. Nicholas did approach me and handed me copies of bonds, believing that it's the same offense, but I don't know for sure. I've got the bonds here in my hand, but I haven't had an opportunity to review them. So I suspect what we can do is arraign him on that charge, and then I'll sort it out with the DA's office, hopefully with either a dismissal or something from that nature. But his name is spelled correctly. We understand the charge, waive formal reading, enter and plead not guilty to that one, and ask that it be carried with the other cause for pretrial.
All right, court finds that Mr. Johnson, having waived the formal requirements of arraignment, cause number CR 24-273, enters his plea of not guilty into the record. We'll set that matter for pretrial on January 21st. We'll carry the docket call and CR 24-166 of even date. Mr. Johnson, have you made any payments to your pretrial release?
Trying to make it today,
Okay, how much can you pay today?
180.
Okay, all right, I'm gonna write that down that you're gonna do that after court, okay?
I think you have to go over to the probation office and pay them at their businesses across the street. So I can give you introduce. Across the street? Yeah. On my street, right? You know, station is across the street. When you walk out the front door, you'll see a multi gas station. Right up. Behind. You can walk there from here. Okay. Yes.
All right, who's next?
Jesus Linda.
Jesus Landa, CR 24-213. Mr. Landa is set for pretrial. Mr. Schmidt, go ahead.
Judge, at this point, we have no contested pretrial. We'd ask for a docket call.
There being no contested pretrial motion, the court sets Mr. Landa for docket call January 21st at 9 a.m. Once he signs, he's free to go. Next. Who? Mr. Mayor, Major, Mr. Major. This is cause number CR 24-214, State of Texas versus Dante Marquez Major. Court finds that Mr. Major is indigent for the purposes of the Sixth Amendment. The court has appointed the Honorable Richard Schmidt as counsel. Go ahead, Mr. Schmidt.
Judge, I've received a copy of the indictment. We've gone over that together. His name spelled correctly. Wait for the reading, enter plea not guilty.
All right, court enters Mr. Major's plea of not guilty into the record, finding he has waived the formal requirements of arraignment. Court sets this matter for pretrial hearing on January 21st.
Judge, do you have a docket? I think February 10th docket for,
Got February 11th.
can I have that one? Thank you.
All right, court sets Mr. Major for pretrial February 11th at 9 a.m.
I need,
Mr. Fernando Hernandez.
yeah, I need him.
Mr. Hernandez, come on. Forward, this is cause number CR 23-162. Mr. Hernandez is set for docket.
Judge, I think we're pretty close to working it out. We'd ask for an additional doc call on him.
January 21st.
Yes, sir.
All right, court sets Mr. Hernandez for docket call January 21st. 9 a.m.
I think the rest will be pleased, Judge.
Don Baxter Schnack. All right, this is cause number CR 24-174. Mr. Schnack, go with you. Would you swear that the testimony today is the truth?
Yes.
Lori, your name is Sean Baxter Schnack, is that correct?
Yes.
Sir, are you a United States citizen who grants rights?
Yes.
Have you ever been diagnosed with a mental condition?
Yes.
Yes. Can you tell me about that?
Schizophrenia.
Okay, are you currently on medication under a doctor's care for that?
Yes.
You are? Do you feel like, Mr. Schnack, that you have a rational understanding of everything that's going on before here today?
Yes.
And you are represented by your attorney, Mr. Schmidt. Are you pleased with Mr. Schmidt, the work he's done for you?
Yes.
And do you have any questions about your paperwork or anything else regarding your plea?
No.
Right. Mr. Schmidt, do you believe your client to be competent?
I do believe so.
Have you explained it on this rise that came in this case and also the advantages and disadvantages of a deferred adjudication plea?
Yes, sir.
And do you believe he's entering into this agreement intentionally, knowingly, and voluntarily?
Yes, sir.
All right, Mr. Schnack, you are charged by indictment with a third-degree felony offense of cruelty to non-livestock animals. That is a third-degree felony that carries a range of punishment of not less than 2 years in prison or more than 10 years in prison and a possible fine not to exceed $10,000. The agreement in your case is upon your plea of guilt, states recommending that the court consider the evidence, not convict you, rather place you on deferred community supervision for a period of 4 years. And the state would be asking the court to dismiss another criminal trespass case under 2024 that would be responsible for reimbursement fees of $535, court costs of $290. Is that your understanding of the plea agreement?
Yes.
All right, Mr. Schnack, then understanding those things, I would ask you at this time, how do you plead to cruelty to non-livestock animals?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes.
Mr. Schnack, has anybody threatened, forced, or pressured you to plead guilty here today?
No.
All right, the court does accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
All right, stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial notice. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
Court will review the evidence. All right, court having reviewed the evidence, finds enough evidence to convict the defendant of this offense. The court follows the plea agreement and recommendation of the DA's office. The court hereby defers the finding of guilt on the third-degree felony offense of cruelty to non-livestock animal, places Mr. Schnack on 4 years community supervision, orders him to pay court costs of $290, reimbursement fees of $535. And the court dismisses under section 1245, cause number 2024-2. Now that cause number is a misdemeanor, a filed misdemeanor, correct? So I see this got a 1245 from Judge Winters, so that don't even take us on to Judge Winters since it was not transferred over.
Yes, sir.
All right, Mr. Schnack, I'm gonna have you come forward if you can. And you're remanded to the custody of the probation department, so they can clear out the terms.
Take this with me. When we're done, I will get you back there and talk to probation. Okay.
Jeffrey Neil Walker Jr. It's cause number CR 24191. CR 24192. All right, Mr. Walker, sir, if you'll raise your right hand and put your oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you?
Yes.
There we go. Your name is Jeffrey Neil Walker Jr., is that correct?
Yes, sir.
And Mr. Walker, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney. Are you pleased with Mr. Schmidt and the work he's done for you?
Yes, sir.
Do you have any questions about your paperwork or anything else that you've read and signed today as part of your plea agreement?
No, sir.
Mr. Schmidt, do you believe client to be competent? And if so, have you explained to him his rights pertaining to this case?
Yes.
Do you believe he is entering into this agreement intentionally, knowingly, and voluntarily?
I do.
You've also explained to him the advantages and disadvantages of a deferred adjudication plea.
I have.
Mr. Walker, you are charged by indictment with a third-degree felony offense of assault on a family or household member by rather circulation and 4191. That does carry a range of punishment of not less than 2 years or more than 10 years confinement in prison However, I see that the plea agreement today, the recommendation of the DA's office is that you be you be allowed to plead guilty to a lesser offense of a class A misdemeanor assault causes bodily injury. That carries a range of punishment of not more than 365 days or 1 year in the county jail and a fine of up to $4,000. I see that the plea agreement is upon your plea of guilty, the DA's office is recommending that the court consider the evidence, not conviction, place you on deferred adjudication for a period of 2 years, along with a $750 fine, plus reimbursement fees of $540 and court costs of $270. In addition, it appears that the state is moving to dismiss your other indicted cause, CR 24-192, in which you were indicted with third degree.
Yes, sir.
All right, understanding the plea agreement, understanding the range of punishment, how do you plead to assault causes bodily injury of a family?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes.
Walker, has anybody threatened, forced, or pressured you to plead guilty to that?
No.
All right, court does accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
Stipulation of evidence is admitted and the court takes judicial notice. Anything further from the state?
Your Honor, only that the state is in compliance with victim notification. Victim has indicated a desire to not pursue any further charges.
Anything further from the defense?
No, sir.
All right, court will consider the evidence. All right, court having considered the evidence, court will follow the plea agreement here today. The court prefers a finding of guilt on the lesser included class A misdemeanor assault on body. Family member, court post offer on 2 years community supervision, orders him to pay a $700 fine, $270 court costs, and $500. Further, the court dismisses cause number CR 24-19. All right, Mr. Walker, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence and then come forward to the deputy. Thank you. Kathy Leha, file number CR 24-70. Ms. Leha, if you raise your right hand. And do swear that the testimony given before today will be true, the whole truth, and nothing but the truth, so help you God.
Yes,
All right. Your name is Kathy Leha, is that correct?
yes,
Ms. Leha, are you a United States citizen who reads, writes, and speaks English?
yes,
Have you ever been diagnosed with any type of mental condition?
no,
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done for you?
yes,
You understand everything that you have read and signed that's in your plea agreement?
yes,
Mr. Schmidt, do you believe Ms. Leha be confident statement?
I do.
You've explained to her her rights regarding the states and also the advantages and disadvantages of a deferred adjudication.
Yes, sir.
All right, Ms. Leha, see that you are charged by indictment with a third degree felony offense of power for elderly individual. However, I see that the plea agreement, the recommendation of the DA's office is that you be allowed to plead guilty to a lesser class A misdemeanor offense of assault on bodily injury of a family member. Class A misdemeanor carries a range of punishment of not more than 1 year and 365 days in county jail and a fine not to exceed $4,000. I see also that the recommendation is upon considering the evidence, the court prefer finding of guilt and to place you on community supervision for 2 years, along with a $100 fine plus court costs and reimbursement fees, $535 for the parents of the child as a condition of community supervision. Is that your understanding of the plea agreement?
yes,
All right, Ms. Leha, understanding the plea agreement. Ask you, how do you plead to the class A misdemeanor offense of assault causes bodily injury?
guilty,
You're pleading guilty to that crime because you are in fact guilty of committing that crime.
yes,
Ms. Leha, has anybody threatened, forced, or pressured you to plead guilty here in court?
no,
All right, the court accepts the defendant's plea of guilt at this time. Mr. Schmidt, any objections to stipulation of evidence?
No objection.
Stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that the state is in compliance, but have been unable to make contact with the victim in the case.
Thank you, Mr. Earl. Anything further from the defense?
No, sir.
All right, then the court will consider the evidence. All right, the court, having considered the evidence, finds enough evidence to convict the defendant. However, the court follows the plea agreement and recommendation of the DA's office. The court hereby defers the finding of guilt on the class of. Court places 2 years to prison. Take a parenting class as a condition of community supervision. Court is sure to pay $270 court costs, $535 reimbursement. Stay on, hereby remanded to the custody of the department, will then carry out the terms and conditions for the sentence, and have you come over to Deputy Martinez. Probation officer to tell you about what's. Adriana Jacobs, Adriana Marie Jacobs. All right, this is cause number CR 24. 101. Jacobs, if you'll raise your right hand, you swear that the testimony you give before today will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, Ms. Jacobs, are you a United States citizen who speaks rights and routinely?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt, the work that he's done for you?
Yes, sir.
You understand everything that you have read and signed?
Yes, sir.
Do you have any questions about?
Yes, sir.
Believe Ms. Jacobs confident and will and the right regarding this case and the advantages and for adjudication.
Yes, sir.
All right, Ms. Jacobs, you were originally invited in the second degree felony offense of burglary of a habitation. I see today that the plea agreement and recommendation of the DA's office is that you fill out guilty to a lesser offense, the class B. Theft of property between $100 and $700. A class B misdemeanor carries a range of punishment of not more than 180 days confinement in the county jail. Also, possible fine not to exceed $2,000. I see that the plea agreement in your case is upon you pleading guilty. The DA's office is recommending that the court consider the evidence, not convict you, but place you on 2 years community supervision with a $500 fine, $270 court costs, $535 in reimbursement. That's your understanding of the plea agreement as well?
Yes, sir.
That's what you're asking the court to approve?
Yes, sir.
All right, Ms. Jacobs, I'll ask you, how do you plead to the class B offense at theft of property greater than 100, less than 750?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Jacobs, has anybody threatened to pressure you to plead guilty in court today?
No, sir.
All right, the court accepts the defendant's plea of guilty. Any objections to the stipulation of evidence?
No objection.
Stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial. Anything further from the state?
Your Honor, only that the state is in compliance and victim in this case is Ms. Jacobs' grandmother. She is supportive of this plea. Also, I would point out that the court called Ms. Jacobs' case. She did not answer. I imagine she was with Mr. Schmidt and the court issued a judgment nisi. Now that she's here, I just wanted to refresh the court's memory so that we can take that.
Yeah, I don't believe that we did call.
Oh, was it another? Oh, I'm sorry, Your Honor.
Jacobs.
I wrote down the wrong case then. I apologize, Your Honor.
It was Jennifer Jacobs.
Okay. Yes, sir. In that case, Your Honor, state is in compliance and the victim is supportive.
All right. Anything further from the defense?
Well, yeah, Judge, along those lines, did you call it, Ms. Jacobs had a medical emergency last time we were in court. I think you took a nice under advisement. Not sure it was ever issued. Maybe that's what he's thinking of.
Well, she was late to court, or she wasn't here when I called her name this morning, and I did call her name, but we didn't have it called in the hallway for the purposes of an ITI.
I got
There was another individual named Jacobs that we did.
I understand, but I'm talking about our prior visit.
I'm not sure.
Okay,
I can research it and figure that out.
I understand. I just want to make sure that, I think you took it under advisement at the time. I think it was last month. And I don't recall whether or not it was ever entered. I'd like to believe it wasn't, but just so we're aware.
We'll research the file and if it was taken under advisement, then the court will not issue it. If the court did issue it, then I'll recall it.
Yes, sir. Thank you.
All right, court's going to consider the evidence. All right, court, having considered the evidence, finds enough evidence to convict the defendant. However, the court will follow the agreement and recommendation of the DA's office. The court defers the finding of guilt on the Class B misdemeanor offense of theft of property. Court places Ms. Jacobs on 2 years deferred community supervision, orders her to pay a $500 fine, $270 court costs, and $535 in reimbursement fees. Ms. Jacobs, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you step over here with Deputy Martinez to be fingerprinted. Mr. Holmes, you're the only one that's left.
I believe so. I hope so.
Mr. Holmes, come on up. This is cause numbers CR 24-55, 56, and 57, State versus Gerald Alexander Holmes. Mr. Holmes, sir, raise your right hand. I'll place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So,
Yes, sir.
all right, good luck. Your name is Gerald Alexander Holmes. Is that correct?
Yes, sir.
And Mr. Holmes, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Schmidt. Are you pleased with Mr. Schmidt and the work that he's done for you?
Yes.
Do you have any questions about your plea agreement or anything else before we go further?
No, sir.
Mr. Schmidt, do you believe Mr. Holmes to be competent?
I do.
And you've explained to him his rights, they pertain to all three cases and also the advantages and disadvantages of a deferred adjudication plea?
Yes, sir.
All right, Mr. Holmes, in cause number CR 24-55, you are charged with the second-degree felony offense of indecency with child by sexual contact. A second-degree felony does carry a range of punishment if you were to be convicted and sentenced to not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice, that is prison, and also a possible fine not to exceed $10,000. I see that the plea agreement and recommendation of the DA's office in this case is for the court to consider the evidence, but to defer a finding of guilt, not convict you, place you on 6 years community supervision, order you to pay a $100 child abuse prevention fine, $290 court cost, $540 in reimbursement fees, and the DA's office is asking the court to take into consideration and dismiss another indecency with a child sexual contact, cause number CR 24-56, sexual assault of a child, cause number CR 24-57, and also unfiled aggravated sexual assault of a child, DA 2023-1295. And in agreement, there appears to be an agreement on a lifetime protective order regarding the victim in this case. Mr. Holmes, is that your understanding of the plea agreement?
Yes, sir.
All right, then understanding the range of punishment and the plea agreement, Mr. Holmes, how do you plead to indecency with a child by sexual contact?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime? And Mr. Holmes, has anybody threatened, forced, or pressured you to plead guilty here in court?
No, sir.
All right, the court will accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
All right, that is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
Your Honor, other than the allocution by the victim who's present today. No.
Is the victims in these cases supportive of the recommendation of the DA's?
Yes, Your Honor.
Anything further from the defense?
No.
All right, the court is going to consider the evidence. All right, the court, having considered the evidence, finds that there is enough evidence to convict the defendant of this offense. Court will follow the plea agreement and the recommendation of the DA's office. Court hereby defers the finding of guilt. Second degree felony offense of indecency with child by sexual contact. Court places Mr. Holmes on 6 years community supervision, orders him to pay a $100 child abuse prevention fine. The court orders him to pay court costs of $290, reimbursement fees of $540. Further, the court takes into consideration under section 1245, indicted cause number CR 2456, indecency with a child sexual contact, cause number CR 24-57, sexual assault of a child, and unfiled DA 2023-1295, aggravated sexual assault of a child. And the court orders, and the court approves and orders the lifetime protective order for the named victim in this offense. Is there a protective order versus, or is there a protective order that encompasses any of the other cases that are being 1245? Is the alleged victim in the other cases the same as the victim in this case?
It is in the other case that was indicted. It is not in the unindicted case, Your Honor.
The protective order is for the victim in CR 2455, the indecency.
Yes.
Court finds that Mr. Holmes, having been prosecuted for a Chapter 62 offense, finds that he is required to register as a sex offender. Has a copy of Chapter 62 been provided to Mr. Holmes?
Yes, sir.
All right. Court finds that the state will need to sign the, I'm sorry, that the defense will need to sign the supplemental admonishments for Chapter 62.
Have I done?
Just you, Mr. Smith. All right, Mr. Holmes, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you come forward to be fingerprinted with Deputy Martinez, and understanding that there's an allocution in this case.
Yes, Your
After
Honor.
which, after time that you're fingerprinted, I need you to go over and have a seat so the victim can allocute. Mr. Hernandez.
Yes, Your Honor.
Get your signature on this 1245.
Yes, if I may approach.
Yes. Got one, but not the other.
Thank you.
At this time, the victim might be allocated.
Yes, sir.
Mr. Holmes, up here, buddy. All right, court has directed the court reporter not to record this allegation. What's your step? That chair moves around, you can adjust it.
My name's Kiara Furr, and I'm gonna read my victim impact statement. My 15-year-old self wrote, "I'm now scared to be around any man alone because of what happened. I could not sleep at night. I got fear of black trucks. Too scared to go out in public because I was afraid of him. I got to where I could not sleep at night because I was too scared. I had to be put on sleeping medicine, depression, anxiety, medicine too, after all that happened. I really did not want to be alive because he took something from me I could never get back. And I will never forget. I remember scrubbing my body until it was all red. I remember looking at myself and hating everything, every part of me. I will forever carry the scars of this man that had absolutely no right to my body. Now that I am 18 years old, I am blessed God kept me going, even though I had no will to live. The first male to ever touch me was a grown man that my 15-year-old self didn't want. The first man that ever touched me forced it on me. I was 15, he was grown. I never wanted that. My 15-year-old self is celebrating. I made it to 18 and had to see the justice I deserve. It took almost 3 years, but God kept me strong. Everything done in the dark will come to light. Romans chapter 12, verse 21 states, "Do not let evil defeat you. Defeat evil by doing good." God bless y'all.
Nothing further, Your Honor. Thank you.
All right. Then we are in recess until 1:30.